This Honorable Court of Criminal Appeals is now in session.
Good afternoon. This is the March session of the Court of Criminal Appeals in Nashville. Our panel today is Judge Kelly Thomas from Maryville, Judge Robert Montgomery from Kingsport, and I am Norma McGee-Ogle from Sevierville. Each of you know you will have 20 minutes per side for your arguments. If you'd like to save any of your time for rebuttal, please let me know before you begin your arguments. Hopefully it will not be too long before we're back in person and can do it that way, but we appreciate your efforts today. Ms. Lindsay, we are ready for the first case.
State of Tennessee versus Demontez D. Watkins.
Good afternoon, Your Honors, and thank you so much for your time and attention today. I am Patrick Hakes for the appellant, Mr. Demontez Watkins. And before I begin, I would like to reserve 3 minutes in rebuttal time.
Thank you.
Yes, Your Honors, we raised 5 issues in our brief for appeal, but today I'm going to focus solely on one. And that one is a case of first impression. And it is the issue of whether the trial court erred when it admitted the scientific evidence related to probabilistic genotyping, or it's referred to in both the state brief and the defense brief as PG or PGS.
Backgrounds from them.
And Your Honors, I would submit to the court before I begin that one crucial piece of information is this. In the entire United States, both at the state level and at the federal level, there are no cases where 6 contributors, 6 DNA potential profiles have been used with software like this, and a court has upheld it. Not one. The second thing I want to point out to Your Honors is this. Mr. Watkins is not arguing that probabilistic genotyping is not valid in certain circumstances. Indeed, it is. But the real issue today for this court is what the ceiling is. How high can we go with numbers of contributors? How much can we push this science before it becomes unreliable? And so, Your Honors, I would submit to this court there are 2 ways that the trial court abused its discretion. And the first way is that the trial court found incorrectly that probabilistic genotyping as a science is applicable in a case like this where there are 6 contributors. And then the second way the trial court abused its discretion is more specific. And that is this. The trial court found that TrueAllele, which is the actual software used, is reliable in a case with 6 contributors like Mr. Watkins. And so, judges, I am going to do my best to stay out of the weeds with the science and the math. But let me give sort of a quick overview of how probabilistic genotyping comes into the picture. This court and trial courts all across Tennessee and the Tennessee Supreme Court are familiar with what is known as gold standard DNA interpretation. And essentially what that is a DNA sample that might have 1 contributor, and typically that contributor is known. So we might get something from a knife handle or gun handle, and we have a suspect in mind. That information is run through a crime lab's computer, and that computer then spits out a graph, and a human analyst with their own eyes looks at the graph and gives a probability of whether it is that person in there or is not. That's called gold standard DNA. And our legislature, like many legislatures, has a statute on the books that says you're not even entitled to a Daubert hearing with that, because essentially we know that that technique is valid. Probabilistic genotyping is separate and apart from that. Probabilistic genotyping comes in where that sample, instead of just having 1 person or maybe 2, is complicated and is low amount of DNA. So it's an even lesser amount of human material in the sample. And it's basically software programs that run a very complicated mathematical formula and try out different sort of pieces to see what the probability of whether a profile is in a sample. And that's what happened here. As it applies to this case, Mr. Reginald Ford was shot and killed in the morning of August 6, 2015. And the lead detective got there the next morning and he asked Metro ID unit to swab the right front pocket of Mr. Ford's pants, specifically the inside of the pocket. The crime lab in Metro Nashville did that. and it generated a report that said this: we believe there's at least 4 people, or 4 contributors is the scientific word, in that sample. But because it's so complex, we can't say whether Mr. Watkins was in there or is excluded from there. The detective then contacted Cybergenetics to run its own program, TrueAllele, to come out with what's called a likelihood ratio. And the number that's really at issue at trial and at the Daubert hearing is as follows. So TrueAllele came back with the following ratio. It said that the chance that Demontez Watkins is not in that sample in the pocket is 1 in 470,000 African-American individuals that are not related. And so the defense filed the Daubert motion and was overruled, and also renewed it at trial and was overruled, and the evidence was admitted. And Your Honors, this court today is going to use several standards. First, the standard in Tennessee Rule of Evidence 702, and then also that in McDaniel and Daubert. And so let me begin with my first point. Probabilistic genotyping, so the science behind the software that was used in this case, is not valid if you have 3 or more in a sample. And the trial court did not explore this and did not credit it. And there are a few ways we know that there are issues when you have a sample with more than 3 folks. The first way is a report that came out in 2016 that's referred to as the PCAST report. It's a mouthful, but here's what that stands for. It's the Presidential Council of Advisors on Science and Technology. And what PCAST was it was a group of individuals from all over, from the academy, from universities, from businesses, from science fields. And their job was tell us about forensic sciences used in courts and how we can get better at employing them and what the limits are. They would report to the White House, they would report to the DOJ and other administrations. And what the PCAST report says is this: TrueAllele and its competitor, which is known as StarMix, you'll hear a little bit about them as well, are very promising and are in fact preferred if you have a low amount of, a low number of contributors. But where there is 3 contributors or more, then there must be more testing to determine whether it is actually valid and doing what we think it's doing. So at the Daubert hearing, Dr. Perlin, who's the owner of Cybergenetics and the software used, TrueAllele here, he testified that the PCAST report should not be credited. And his explanation was relatively muddled. It was something about how one of the participants in PCAST was improperly titled. Instead of being known as, I think, a statistician, he was actually a forensic biologist. And I might have that flipped, but his quibble was they have labeled someone improperly. He also made a tenuous argument about how someone involved in the study sought to benefit if the study was curbed a certain way. Now, the trial judge in her order did not explore any of that. She merely said, well, we're not going to credit PCAST because Dr. Perlin has said it should not be credited. Aside from PCAST, the next authority you can look to see that in cases like this, where there are more than 3 contributors, probabilistic genotyping is suspect, is the NIST report, which came out in 2017. And the NIST report essentially said everything about probabilistic genotyping should be tested more and should be questioned, including the mathematics behind it, because it's so complicated. The NIST report said jurors often do not understand likelihood ratios, and that there's human subjectivity that goes into developing a likelihood ratio. With that, I'll move on to the larger topic, which is the specific software, in this case, TrueAllele. The trial court erred by finding that TrueAllele can be used in a case with 6 contributors. Now, the trial court order on the Daubert motion is 29, I believe it's 29 pages. There is 1 paragraph dedicated to the reasoning as to how TrueAllele is applicable in Mr. Watkins' case and whether it's valid. And in that paragraph, the trial court says the following. Well, first, the court goes through and summarizes the ratios I described earlier, just stating the facts as they were reported from TrueAllele. And then the court says the following: based on all the evidence presented, TrueAllele testimony is reliable as applied in this case. That was the whole and sum of the reasoning for a scientific method that has not ever been approved in the state, and a scientific method that has very little, if any, evidence to suggest that when you have this many contributors to a DNA sample, it is valid. And again, I want to be clear here. The argument is not that probabilistic genotyping is invalid. It's that there is a ceiling, and the trial court failed to understand that Mr. Watkins' case pushed it beyond that ceiling to a breaking point. So all experts that testified, both at trial and at the Daubert hearing, spent much time talking about validation studies. And Your Honors, a validation study is simply a test to test a specific instrument. Is this thing doing what we think it's going to do? Does it give the answer we expect it to give? And does it routinely give the same answer? But the most important part is it also shows where that breaking point is, or ideally, it shows where that breaking point is. In this case, probabilistic genotyping company Cybergenetics submitted 34 validation studies. Now, of those 34, 23 were performed, written, and then actually published by the company itself who sells the product. Aside from that, there are 7 peer-reviewed journal articles, which, as this court knows, is a part of the Daubert standard. Of those peer-reviewed articles, however, 6 of them were written by Dr. Perlin, the owner and the person who stands to benefit financially when Crime Labs purchase his product. And the state and the trial court both focused on how one of these studies was independent. The one study that is claimed to be independent, there is a note that includes Dr. Perlin as a, quote, professional guide. All that to say, when the trial court considered the validation studies, it did not explore Dr. Perlin's involvement, and it did not adequately explore whether they were independently done. The next issue with validation studies is that the trial court wholly discarded the lack of internal testing. And so, Your Honors, one type of validation study is done by the crime lab itself. So it figures out the boundaries of how to use the software. That's referred to as an internal validation study. And in Mr. Watkins' case, the Metro Nashville Crime Lab had done 0 testing of TrueAllele software. It hadn't even purchased the license to TrueAllele at the time. And this is important for several reasons. One, as I've already explained, it shows us where the boundaries is per crime lab for that software. You know, every crime lab is different. They have different protocols, different instruments, and they train their employees differently. And so they have to put the software through its paces and figure out its boundaries. But secondly, and most importantly for this court, in the trial court's order, the judge noted a case with the case name of Hillary, and that's out of New York. Now, that's not a TrueAllele case. It's a competitor case, StarMix, that I mentioned earlier. And what happened in the Hillary case was on all fours with what happened here. In the Hillary case, StarMix had not been internally validated by the New York State Police. They had done no testing. And based on that issue alone, the trial court judge in the Hillary case excluded any testimony regarding probabilistic genotyping. And related to Mr. Watkins' trial court order, the Daubert order here, the judge actually mentions Hillary, as I said, on pages 24 and 25, and she mentions that the evidence was excluded because of the lack of internal validation. However, in the rest of her order, she doesn't say anything about how Mr. Watkins' case is different, and the Metro Crime Lab didn't need to do internal validation studies. Regarding the rest of the validation studies, those that are performed by Cybergenetics, the trial court erred when it placed too much emphasis on a case called Foley, which is a case outside of, from the Pennsylvania Appellate Court in 2012. The Foley case says, well, first, Foley was Cybergenetics' maiden voyage. It had never been admitted in any court in the country ever. And there were only 2 peer-reviewed studies. And the important thing about Foley is the context. That was 2012. Probabilistic genotyping, people were still quibbling about that floor, whether it could be used, and it was better than human analysis. And so things were very different then. The judge had a very different landscape. And the trial court in Mr. Watkins' case just simply credited, well, this Foley case has admitted it, so we are going to say and cite it as something that should be admitted as well. The trial court also failed to understand and failed to really examine the amount of contributors that this software has been used with before. And that is a key issue. When the experts from cybergenetics testified at Mr. Watkins' trial, they testified that there were 6 people, or rather the information that they presented had to do with 6 people in the profile, six profiles in the sample, excuse me. When that happened, cybergenetics had no reported studies that said the software could do that. Not one. Now, the trial court notes, and so does the state in its brief, that there is a study that existed at the time where Dr. Perlin asserts his software could go out to 10 individuals. But there's a couple things about that are actually incorrect. So first, that study that the state relies upon in its brief and the trial court did as well, that was an unpublished study. It was an unpublished, not peer-reviewed study. At the time the trial judge made the decision that 6 contributors was something where the software could be used, that study did not exist. Now, Dr. Perlin included it in his materials. Of course, he included a draft of it, but it had not been vetted and published to the same extent that the other studies had. The other thing I would note for this court is when questioned about that study, Dr. Perlin essentially said, I don't know if other companies who do the same thing are going out to 10 people. I can't say. And what that really suggests is that, no, they were not going out to 10 people because that would be the generally accepted scientific standard we look for, like in Daubert. TrueAllele is the only company that asserted to do that at that time. Your Honors, lastly, regarding the validation studies, this court, since it is a novel issue, should really consider the different types of disciplines that are involved with this type of software. The proper standard isn't really just to look at DNA. I submit to this court, you should consider computer programming, you should consider biology, you could also consider statistics. And that's what the defense expert, Mr. Nathan Adams, testified to at the Daubert hearing. The trial court mentioned Mr. Adams twice in her 29-page order, and she did not credit anything he said. One thing he said was that when developing this software, which by the way is 170,000 lines long, when developing this software, it would be best practice if Dr. Perlin followed the suggestions from the Institute of Electrical and Electronic Engineers. And Dr. Perlin said, I don't do that. I just don't. And the trial court did not give that any weight. And Your Honors, I see my time is coming close. The last thing I will tell you before turning to the state is this. Earlier today, my colleague, Mr. Jeffrey DeVasier, filed a letter of supplemental authority, and he notified this court of a case that is persuasive for what we're dealing with today.
We did receive that.
Very good. Thank you, Judge. And quickly, I will say, that court is the only higher court to have reviewed this trial court's order before Your Honors. And that case is State v. Pickett. It's not reported yet. It was issued just last month. And the site is 2021 Westlaw 357765. And the main issue in that case was whether cybergenetics had to reveal its source code. So it is not the same issue of admissibility as we're dealing with today. However, the appellate court specifically refers to this trial court order as a, quote, house of cards type of effect. And what the appellate court says is that once one court allows admission for software like this, or for really any scientific evidence, then other courts look to it, and it begins to have a domino effect without a real searching review. In that case, in New Jersey, there were some similarities with the case before you today. TrueAllele had never been used in the state, and it did involve a shooting case, but the real battle was over the source code. And there's an 80-page opinion that spends a lot of time on the validation studies. And unlike the trial court in Mr. Watkins' court, what the appellate court did there was it credited PCAST, and it actually considered what the defense expert said, which the defense expert was the same as the one in Mr. Watkins' case. It was Mr. Nathan Adams. Your Honors, I believe my time is coming to a close, so with that, I will yield to the state.
Oh, you still have your rebuttal time left, but you are almost into it.
Okay, I will yield to the state. Thank you, Judge.
Good afternoon, Your Honors. May it please the court, Austin Watkins appearing on behalf of the state of Tennessee. Your Honors, as you've heard from the appellant, although there are several issues that have been raised for this court's consideration, the most significant is this issue of first impression regarding the admissibility of expert testimony based on probabilistic genotyping. And here, the trial court properly exercised its discretion to admit such evidence based on its findings that probabilistic genotyping is foundationally reliable and was methodologically reliable as applied in this case. Therefore, Your Honors, the judgments of the trial court should be affirmed. Your Honors, essentially, this is a lot for the court to process, and it's going to have a lot of work to do as it drafts its opinion. But basically, the expert testimony here that was used in this case about the likelihood that the defendant's DNA was contained in a complex DNA mixture of multiple people, which was found in the victim's pocket. What the proof in the record shows that that was relevant testimony and it was reliable evidence in this case. And just briefly, without spending too much time on the facts, essentially what this was relevant to in the state's case was to help support its charge of felony murder. It was trying to show that because the defendant's DNA was found in one of the victim's pockets, it supported this theory that the victim was killed during the perpetration of a robbery, which was why the defendant was rummaging through his pockets looking for valuables. And essentially, Your Honors, to speak kind of to the specific issues that the defendant is raising with regard to the applicability of probabilistic genotyping in this particular case. Before we get into it, Your Honors, I did just want to point out that this is going to be before the court on an abuse of discretion standard. And essentially what the Daubert McDaniel standard is asking this court to do, or what the trial court is tasked with doing, is providing a gatekeeping mechanism to determine whether the science that is going to be considered and presented to the jury, does it rest on good grounds? And just because there are competing scientific theories, just because there may be some indication that that an expert's opinion is incorrect to some degree, there is supposed to be wide leeway given for the crucible of cross-examination and for counter-expert testimony to be where, differences of opinion about the way the science should be used is to be played out in court. That it's not necessarily going to be one of exclusion. What this court or what the trial court is trying to determine is the science generally accepted? Is it foundationally reliable? And was it generally reliable as applied in a particular case? And if that's the case, then the court should opt for inclusion and then let the parties put on the experts for the jury to explain any inconsistencies or concerns that one party might have about it. And so moving to the particular concerns that have been offered up in this case, the record supports the trial court's finding that the program, True Allele, was methodologically reliable as applied in this case. Your Honor, the state's expert, Dr. Perlin, the court recognized him as a world-renowned expert who was qualified to testify here. He had a PhD in mathematics, had a PhD in computer science, and he had a medical degree. And what he testified to about the PCAST report specifically was essentially that it was a policy document and that the panel of broad scientists in all types of different fields who opined about the use of probabilistic genotyping software, that panel was not representative of probabilistic genotyping experts. It was not made up of people who would have appreciably understood the nature of this tricky type of expert evidence. It also pointed out that there was heavy reliance by the panel on one particular source who was biased, who not only was cited incorrectly about his occupation, but was shown later to have had a grant funding conflict of interest that was borne out later. Yeah, Dr. Perlin also explained how that the PCAST report was internally inconsistent based on the different sources that it relied on. And he was also pointing out that its ultimate recommendation about the circumstances in which probabilistic genotyping software should be restricted, that it was based on validation studies that were available at that time. And since then, which was 2016, the validation studies have continued to grow and show that this evidence is more reliable in more complex mixtures with more contributors. And so, Your Honors, it was appropriate for the trial court, when presented with that explanation from the expert here, to choose to not put inordinate amount of weight on the PCAST report. It was simply a recommendation. And Your Honors, it has been criticized by other institutions since. The Department of Justice has released a report criticizing that particular PCAST report, specifically explaining why the FBI's use of star mix is acceptable, and that would be a different software system here. But the point still stands that PCAST has problems, so it was not unreasonable based on the proof that's in this particular record with an expert speaking specifically to that report for the trial court to decide that it didn't want to put essentially dispositive weight on the PCAST report. This other report, the NIST study that the appellant has mentioned, as the state points out in its brief, it just is not very clear at all that there was any indication that Dr. Perlin was actually presented with that report and specifically asked about the conclusions in the NIST study. So without the expert being given a chance to essentially explain how his process either comports with the study or the study is not applicable, it's going to be difficult for this court to rely on that. And essentially what my understanding of the report is that it essentially opines that probabilistic genotyping software should only be applied in single source samples. I mean, very, very uncomplex mixtures. But the whole point of this emerging field is to use it in complex mixtures. And its primary concern was based on jury comprehension, that juries can't adequately understand what a likelihood ratio is. And the nature of that criticism, Your Honors, it goes directly towards what the purpose of the trial is, to have the adversarial process help educate juries about the significance of the likelihood ratio or a matched statistic. So the idea that maybe this science and this mathematics is just too complex for a jury to understand, well, that just kind of undercuts what the principle of the jury system is that we rely on in this country. And so if the defendant felt that this information was too complex, that was something that his expert was, should have been able to achieve by explaining how accurate or how little weight should have been given to the ultimate statistic that was presented to the jury to show the likelihood that the defendant's DNA was contained within this DNA mixture. Your Honor, moving on to, there's also been some mention of the computer programming standards mentioned by the defense expert. And I would, before I get into that, briefly point out the defense expert who testified at the McDaniel hearing in this case, he had a bachelor's degree in computer science and had completed some graduate courses in computer science. So his area of expertise was pretty circumscribed. I mean, it was limited to him essentially really trying to opine about what his opinion was about, or should have been limited to what his opinion was about the computer programming for true allele. And so essentially one of the things that he was concerned about was that this program doesn't necessarily follow any computer programming, the binary zeros and ones kind of writing of the language doesn't follow any applicable standards, and he specifically cited the IEEE standards. Well, what Dr. Perlin explained when he was asked about those standards was he said, one, the forensic science community has not adopted those standards as being applicable to the community. He did not understand it to have any purported application to this type of a computer system. And Your Honors, on cross-examination, the defendant's own defense expert who was opining about this, he admitted that his own company's software did not completely follow those standards. So any concern related to that, Your Honors, really just didn't bear a whole lot of this weight and didn't merit a whole lot of consideration by the trial court. Your Honors, then moving on a little bit to this concept of independent testing that the defendant has brought up. Dr. Perlin did a pretty good job of explaining how difficult it was to have truly independent testing in this type of a context, where he said, basically it's hard to find people who don't have monetary interests, who are interested in expending their resources to provide something to essentially credit your product. So it's not uncommon at all in the science field to have studies that are done in conjunction with a developer and may involve multiple parties, or that one particular entity itself. And Your Honors, in our notice of supplemental authority, providing the Sixth Circuit's opinion recently in the Gesantiner case, if I'm pronouncing that correctly. There's some helpful discussion about peer review and independent studies, and the court acknowledges the difficulties with finding truly independent studies and said, look, under the standard of review here, what we're looking for is just because something's not truly independent doesn't mean that the study is wrong. And part of what the peer review process is, even if the study was done non-independently, the peer review process is there to help cut against any potential bias. And so here, there have been seven peer-reviewed studies done of true allele work, and 4 of those involve synthetic DNA samples. 3 of them involve actual real-world samples obtained from cases. And one of the peer-reviewed studies was largely independent. Some of them have done in conjunction, but the whole point of having peer review is to help show that those studies hold up to what is expected. The peer review is not done by Dr. Perlin or, Cybergenetics, the company at issue in this case. It's done by independent peers. That's the whole point of that process. And so there is a wealth of information showing that, and to be clear, and I'll talk a little bit more on this later, the peer-reviewed studies validated true alleles application in cases up to 5 contributors. And so here, Your Honors, we've got a mixture that pretty much everyone agreed was either 5 contributors or 6. That was the true alleles thought the best explanation of the DNA in the mixture was 6.
Was the fact that one of the contributors may have been the defendant's brother, is that ever addressed, or does that have an impact?
Your Honor, it was addressed by the the state's expert at the Daubert hearing. And what the expert said was relatedness is something that will affect the accuracy of the likelihood ratio. There were not any calculations done to account for relatedness in this case. And part of that was because they didn't have any additional samples. But what the expert opined, Your Honor, specifically was that based on the studies that he has seen on the expert's experience, that doing the calculations to account for relatedness would not have had an exclusionary effect in this case. I think he offers a number in the transcript about how much he thought it would have affected the ultimate number specifically in this case. And he thought that it wouldn't have had a relevant impact specifically here. And part of what the defendant doesn't explain is even if there was some indication that relatedness might have affected the results, it still would have had to have pointed to one of the co-defendants, which still supports the theory that one of these men had their hands in the victim's pocket to support this theory of felony murder. And so ultimately, that's a little bit of a red herring here because there was no connection between the victim and the co-defendants. There shouldn't have been any mixture that contained any DNA from the victim and any of these co-defendants. No, there should not have been a mixture. These were complete strangers is what is borne out by the record. And so, Your Honors, that is kind of the limited extent to which the Daubert hearing got into the issue of relatedness. And I would point out, Your Honors, that the defense expert did not provide any counter testimony to, explain in his opinion, how relatedness would have affected the accuracy of the calculation. Okay, right? So does relatedness mean the entire system breaks down where the result has 0 accuracy, or is it, well, rather than it being a statistic or a probability that is a certain amount, it's reduced by another amount, but it still can be, broadly accurate, even if it's less precise. And so the state's position, Your Honor, I think that would be supported generally by the trial court's order, is that this was the type of question that would have been appropriate for the parties to discuss through cross-examination or through counter-expert testimony at the trial. That if another, defense expert wanted to come up and say, well, look, here's how problematic this failure to account for biological relatedness is, that's something that should have been presented to the jury. And I think the defense expert maybe did briefly touch on that at trial. And so this was something that the jury was able to consider but there really just was no hard and fast evidence about what the specific impact of this particular aspect of the analysis would have been, Your Honors. So then moving on to the number, Your Honors, of contributors. What Dr. Perlin, the state's expert, testified to is that there had been a published study validating true alleles application in mixtures up to 7 individuals, and that there was a forthcoming study that would have validated it up to 10. And so given that there had been studies that showed that this product, this computer system could be applied to mixtures that were this complex, that shows that it was reasonable for this expert to apply this program to a mixture containing 5 or 6 individuals. So even though this 10 individual study was forthcoming, and it may have been kind of pushing the boundaries of what the other probabilistic genotyping softwares were doing, we're not talking about a 10 contributor case. It is much closer to what the peer-reviewed studies and this other validation study that went up to 7 showed. We're talking 6 or 7 individuals here. And all of the data was made available to the defense expert, where they could have come in. They could have done their own independent validation testing of true allele. They were given access to the computer program. They could have made their own synthetic sample, run it through the program, and see whether or not it was giving a reliable answer. Is it accurately sussing out these different contributors in a sample where you know what is in the sample, right? That's what the validation study is. You know what the results should be. Let's test it against this program and see if it is identifying the right types of, is it making inculpatory findings? Is it making exclusionary findings appropriately? And no one at the, none of the defense's experts, there were 2 different experts, one at the Daubert hearing, one at trial. None of them attempted to do their own validation of true allele. Then none of them tried to double test or double check the samples at issue in this case. And so what the science shows is that when there's validation studies that suggest that the program can be reliably applied with a mixture this complex, then it's not abuse of discretion for the trial court to say, hey, okay, this is something that can go to the jury. And if the defense wants to cross-examine the expert about, how many validation studies, the extent of the validation, or something to that effect. And to be fair, the state's expert, testified about his understanding, what the study showed about how the more contributors that are added to a DNA mixture, how that reduces the likelihood ratio. So the whole purpose of this complex, computer software and the math problem is it accounts for how much data it has. So when it is less certain because there are more pieces, it gives a lower number. And the number in this case was not particularly overwhelming. I mean, it was 477,000 times more likely that the defendant's DNA was in this mixture than it was not. And you can contrast that with what the likelihood ratio was with the victim. It was over 200 trillion times more likely that his DNA was in that mixture in his own pants than not. And so that was something that the jury had before it that it could consider of what are the strength of these ratios, and when that the experts could talk about and could point to the studies kind of showing here's what we understand about the way that a likelihood ratio is more accurate or less accurate based on a variable such as the number of contributors. So this is something that under the McDaniel standard, the parties should have been able to let their experts discuss for the jury. This is not a basis for exclusion when there were studies to show that application under these circumstances had been shown to be reliable previously.
You said one study approved or said it would work at 7 contributors, is that right?
That's right, Your Honor. And to be clear, that was not a peer-reviewed study. So it was a published study. I believe it was independent. It was from cybergenetics, but there was no counter study. There's no evidence to show that true allele has ever been inaccurately applied in such a situation. So it's not half the studies or a quarter of the studies. I mean, it was a single study at the time of the hearing that had gone up to 7. And then there was a forthcoming study that was going to show up to 10. And
how independent was that study? Who did it?
I believe it was done by cybergenetics. I don't think it was a collaborative effort or it was independent. I mean, it was done by the company that created the software. But that doesn't mean that the study is wrong, Your Honor. So that's, bias in the study can be something that a counter expert can come in and argue to a jury.
Is the independence of the study not something that's taken into account, or is it in McIntyre and Dahlberg on peer review?
Your Honor, certainly it goes into the mix. Absolutely. It's one of these, factors that the court can consider when it's.
Well, then why should we ignore it?
Well, I'm not
Just
asking.
because there's only one and that nobody said anything contrary.
Well, Your Honor, I'm not asking this court to ignore it. I'm simply pointing out why it was not illogical or an abuse of discretion for the trial court to find that the fact that a study had been done, it was published and it was available for anyone, a counter expert to come in and to show how the study was inaccurate, that somehow this potential for non-independence affected the results.
Could they even do it? Did they have the information to do that? I got the idea that this doctor basically was the only person who would have enough information to test the validity.
No, Your Honor. The record shows that the defense had access to the underlying source code, the programming, and they had access to use this program and apply it to any samples that they saw fit. They could have done their own validation up to as many contributors as they wanted to using this exact program. So this was not a situation where this was the one person who could have done this. The whole point of it being a published study is all of the things that they relied on, their parameters, the samples they used, how they conducted their internal validation up to 7 contributors. That was made available for someone to come in and be critical of that study. I mean, they could have come in and said, well, yeah, you're saying that you validated it up to 7 contributors, but here's all the problems with why this study does not support what you're saying it supports. So, Your Honors, I mean, it is only one study up to this point, and it is something that can be considered, but it's also not something that has to be dispositive one way or the other. This court can look at the nature of the independence, but it kind of makes sense. If it had been peer reviewed up to 5 contributors and we're using the same processes and we're just adding 2 more, DNA profiles to the mixture, the mathematics is still the same. It's still applying. And all the study was doing was to show specifically, we have these known samples. We know what the results should be. We're putting them into our program and we're getting similarly, reliable results with more complexity in the mixture. And that's just a natural extrapolation of all of these other, studies that had been done, including non-independent or including independent ones and including peer-reviewed ones that were showing validation up to 5 contributors. So this was pushing the ceiling here, but it was not like there was no precedent from the lab's own, use of its product when it was applying it to a mixture that was this complex.
Thank you, counsel. I think you've used your time and we've given you additional time to answer some questions, but we do need to have enough time for the rebuttal time that's been saved. This is a little different. We're virtual and we don't have a lot of flexibility as far as time.
Yes, Your Honor, I understand that. Absolutely. So thank you for Your Honor's time. The state would ask you to affirm.
Thank you.
Thank you, Your Honor, and thank you, Mr. Watkins. I'll address several of the state's points with my remaining time. And the first is a factual one. Let's be very clear. The number of contributors at issue is 6. It's not 5 or 4, it's 6. Because that is the information that cybergenetics used and used at trial to report the likelihood ratio that the jury got. The second issue that Mr. Watkins, mentioned just now was relatedness, and he was responding to Your Honor's question. That is a great question. And that is a question that was brought before the jury and that was asked to Dr. Perlin, the state's expert at the Daubert hearing. Dr. Perlin, unsurprisingly, made the assertion that it really doesn't matter. It doesn't matter if people potentially in the sample are related. Sort of similar to other things Dr. Perlin said, he explained it in an esoteric way that was unsatisfactory to the defense, which is why we brought it up again at trial. But the reality is, Judge, in this case, there were 4 co-defendants. Of those 4, 3 are related by blood. Mr. Demontez Watkins, the appellant here today, his brother, Troyvonte Watkins, and then his cousin, Devontae Sherrill. Those 3 are related by blood. Now, Mr. Watkins just told you that, there were no samples for the state to run on the co-defendants to determine whether they were in the sample or not. All 4 co-defendants at some point in time were held with a very high bond on a felony murder charge. If the state sought to get those samples, it could have easily done so with a search warrant, but it did not. The next point I'll address is that the number 7, the study that we've been addressing with Judge Thomas and Mr. Watkins, that study, as Judge Thomas pointed out, was done by cybergenetics. It was paid for, it was researched, and it was produced by cybergenetics. Mr. Watkins stated that it's closer to the peer-reviewed studies. Well, that's incorrect. And in fact, in his argument just now, Mr. Watkins mentioned that the FBI has since said it is okay going with higher contributors. But the important thing about that, and this is noted in the trial court's order, which is why it's important, the FBI goes to 5. It does not go to 6. And it does not use true allele. It uses star mix. So even then, we're still dealing with a square peg in a round hole type of situation. And lastly, I want to address the question Judge Thomas brought out regarding the ability for a defendant or the opposing party to validate. I want to address this court to some of the back and forth that was had about the source code at the Daubert hearing. The source code is the backbone for true allele. It's the sort of lifeblood that makes the program do what it does and give the likelihood ratio. Dr. Perlin testified and provided in discovery to the state and then to the defense a list of requirements that we would have had if we wanted to actually view the source code to see if it's doing what he says it does. Really important about that is if we did that, he testified it would take 8 years to review the 170,000 lines of code. He testified that in those 8 years, Mr. Watkins would be financially responsible for paying for a security guard who would be on site. Any expert that we had who went there could not bring any electronic material. They could only bring, I think, a pencil. So that is an important question, Judge Thomas. And the reason I bring that up is because this shows the opaque nature of what Dr. Perlin is doing with cybergenetics and why we are at the ceiling. And it is not a weight issue. It is an admissibility issue because there is no independent testing that shows that as it was applied in this case, this technology can be used with 6 contributors, 3 of whom could have been related. And so, Your Honor, with that, I'll rest on my argument in my brief. And I thank you so much for your time. Thank you.
Thank you for the very good briefs and the arguments. That concludes the arguments on this case. Thank you, counsel.
Thank you.
This honorable court of criminal appeals is now in recess